Hi everyone, I am Ayushi Jain working as a legal intern with LEXIS and Company. Today in this video I am talking about a doctrine of indoor management. The doctrine of indoor management, also known as truncated rule, is a 150-year-old concept which protects the outsider against the action done by the company. Any person who entered into the contract with the company to ensure that the transaction is authorized by the article and memorandum of the company. There is no requirement to look back into internal irregularities, and even if there is any irregularities, the company shall be held liable since the person has acted on the ground of good faith. To observe the concept of this doctrine, it is important to understand the concept of doctrine of constructive notice, which was discussed in yesterday's video. If you don't watch it, then please go and check the previous video of doctrine of constructive notice. The doctrine originated from the Redmark case, Royal British Bank versus Truncate, 1856. The facts of the case are as follows. The article of the company provided for the borrowing of money on the bond which required a resolution to be passed in a general meeting. The director did acquire the loan but failed to pass the resolution. Then the repayment on default, and the company was held liable. The shareholder refused to accept the claim in the absence of the resolution. Held, the company shall be liable since the person dealing with the company is entitled to assume that there has been necessary compliance with regard to internal management. The rule was further endorsed by House of Lords in Mahoney versus East Holyford Mining Company, 1875. In this case, the article of company provided a check to be signed by two directors and countersigned by a secretary. It later come to light that neither the director nor the secretary signed the check was appropriate properly. Held, the person receiving such check shall be entitled to amount since the appointment of director is a part of internal management of a company, and a person dealing with the company is not required to inquire about it. The above in view held in the case of House of Lords in Mahoney versus East Holyford Mining Company, supported by the section 176 of Companies Act 2013, which state that the defect in appointment of directors shall not invalidate the act done. The doctrine provides the third party who enter into a contract with the company is to protect against any irregularity in internal procedure of the company. The third party cannot find out internal irregularities that take place in the company, hence the company will be held liable for any loss suffered by them due to these irregularities. The doctrine of constructive notice protects the company against the claim of the third party, while the doctrine of indoor management protects the third party against the company procedure. Exception to doctrine of indoor management. The exception to the doctrine of indoor management that has been judicially established, which provides circumstances under which the benefit of indoor management cannot be claimed by a person dealing with the company. Knowledge of irregularity. This rule does not apply to circumstances where the person affected has actuary or constructive notice of irregularity. In Howard versus Painted Ivory Manufacturing Company, 1888, the article of a company empowered the director to borrow up to £100. The limit could be raised, could not, provided consent was given in the general meeting. Without the resolution being passed, the director took £3,500 from one of the directors who took debentures. Held, the company was liable only to the extent of £1,000. Since the director knew the resolution was passed, they cannot claim protection under the Tuckett's rule. Suspicious of irregularity. In case any person dealing with the company is suspicious about the circumstances revolving around a contract, then he shall inquire into it. If he fails inquiry, he cannot rely on this rule. In case of Anand Bihari Rao versus Dinshaw and Company in 1946, the plaintiff accepted a transfer of property from the accountant The court held that the plaintiff should have acquired a copy of the power of attorney to be confirmed the authority of the accountant. Thus, the transfer was considered to be a void. The third point, forgery. Transactions involving forgery are void ab initio, null and void. Since it is not the case of absence of free consent, it is a situation of no consent at all. It has been established in the Lydian versus Great Finger Consolidated Case 1906. A person was issued a share certificate in a common seal of a company. The signature of two directors and a secretary were required for a valid certificate. The secretary signed the certificate in his name and also forged the signature of two directors. The holder contended that he was not aware of the forgery and he is not required to look into it. The court held that the company is not liable for forgery done by its officer. Thank you.